section will focus on a 2025 update with new developments in harassment and discrimination. 2 laws specifically, the ADA and the PWFA, have been updated, and several state laws have been enacted that affect employers. This section will focus on pregnancy as a disability. While the Americans with Disabilities Act does not specifically address pregnancy, many of the conditions that are pregnancy-related could be protected by the ADA, so you should be aware of some new developments in the law. The Pregnant Workers Fairness Act, or PWFA, is a landmark piece of legislation that aims to protect the rights of pregnant workers in the United States. Signed into law in December 2022, as part of the Consolidated Appropriations Act of 2023, the PWFA marks a significant milestone in the ongoing fight for workplace equality and fairness. This comprehensive act addresses the unique challenges faced by pregnant employees and ensures that they receive reasonable accommodation to continue working safely throughout their pregnancy, unless the accommodation would cause the employer an undue hardship. Recognize that the Americans with Disabilities Act covers a variety of pregnancy-related conditions when they significantly limit a major life activity. Some of these conditions include gestational diabetes, placental abruption, lumbar lordosis or severe back pain, deep vein thrombosis, embolism or stroke, carpal tunnel syndrome, mood disorders related to pregnancy, migraines, severe morning sickness, shortness of breath and fatigue, reflux, hemorrhoids, hypertension, urinary tract infections, and varicose veins. There may be other conditions that also may be protected by the ADA. These conditions could be considered disabilities under the ADA, requiring employers to provide reasonable accommodations. So work with your HR department to ensure that your employees' rights are being protected. Now let's focus on several employment law-related updates for the state of Illinois for 2025. Illinois has recently made significant updates to its employment laws, for example, expanding protected categories under the Illinois Human Rights Act, IHRA, and several new laws approved by the Illinois General Assembly are aimed at protecting and expanding the rights of employees in the state. The new measures' effect will also be felt by employers who would likely need to examine their policies and practices for the new year. These laws become effective January 1st, 2025. The first major law is family responsibilities. Employers will be prohibited from discriminating against or harassing an employee based on their family responsibilities. This would include providing personal care to a family member, such as ensuring their medical, hygiene, nutritional, or safety needs are met. Another new law expands the Illinois Whistleblower Act. HB 5561 expands on the definitions and protections afforded to employees under the Illinois Whistleblower Act. Specifically, the prior vague term retaliate has been replaced by retaliatory action, which means not only taking adverse employment action against an employee that would dissuade the employee from disclosing information under the Act, which would include information about immigration status, but also threatening to do so. And the Artificial Intelligence in Employment Decisions law by the General Assembly, which was passed, prohibits discrimination in private sector use of artificial intelligence in making employment decisions. Under the new law, employers may not use AI that has the effect of subjecting employees to discrimination based on a protected class under the IHRA. Employers are also prohibited from using zip codes as a proxy for protected classes. The measure requires employers to notify employees of the use of AI to make or aid in employment-related decisions. Reproductive health decisions are now protected by the IHRA, which prohibits discrimination based on reproductive health decisions. This includes decisions regarding contraception, fertility or sterilization care, assisted reproductive technologies, miscarriage management care, and prenatal, intranatal, or postnatal care. And there are changes to the Illinois Personal Records Review Act. There are updates that are set to expand protections to employees seeking review of their employment files. The amendment makes changes to Sections 2, 9, 10, and 12. These changes provide additional clarification and guidance as to employer responsibilities, employee request procedures, and potential consequences for inaction. And finally, the statute of limitations has been extended for filing a discrimination claim under the IHRA. It's extended from 300 days to 2 years. This gives individuals more time to file a claim. There are several other employment-related changes as well, so check with your HR department to ensure that you're up to date on the newest developments.